Welcome back. Today we'll be handling a topic I decided to caption dispute resolution. Dispute resolution. Well, still on risks and the need to protect ourselves and the business interest. One of the preemptive steps you may wish to take is to agree on a dispute resolution strategy prior to executing any high net worth contracts or forging any legal relationship. You see, dispute resolution fundamentally can be categorized into two major parts: the traditional and the alternative dispute resolution, that's the ADR processes. Ironically, what we now have as the traditional process, that is the court system, used to be the alternative dispute resolution process thousands of years ago. And what we now have refined as the alternative used to be the very informal and the traditional. As what goes around keeps coming around, we may end up having the ADR process becoming traditional and our court systems reverts to ADR. Anyway, in a bid not to confuse you further, let me describe the term simply as a number of processes that can be used to resolve a conflict, dispute, or claim. As established above, dispute resolution can be divided into two major categories. First is the adjudicative process, such as litigation, in which a judge or jury determines the outcome of a matter. Then the second one is the consensual process, such as collaborative law, arbitration, mediation, conciliation, or even negotiation in itself, in which the parties attempt to reach an agreement. You see, the latter is an area that has become more attractive for business in order to preserve relationships. By the latter, I'm referring to alternative dispute resolution processes. It saves time and sometimes saves money. But permit me to refer to it as ADR, which can be partly defined as a means of settling an issue without going to court. ADR includes dispute resolution processes and techniques that act as a means for disagreeing parties to come to an agreement without exploring the option of litigation. Common forms of ADR include, but not limited to, conciliation, mediation, arbitration, negotiation, neutral evaluation, collaborative law, settlement conferences known as pre-trial conference in Nigeria. So, due to constraints of time and space, we will focus on arbitration, which is commonly seen in legal agreements under the arbitration clause. Arbitration is a form of alternative dispute resolution where parties agree not to take their dispute to court. Instead, they agree to resolve the dispute by hiring an arbitrator, or sometimes arbitrators, to hear both sides and make a decision which is expected to be binding. By agreeing in advance to arbitration, the parties are waiving their constitutional rights to the adjudicatory services of a court of competent jurisdiction. Typically the arbitration decision is meant to be legally binding and not appealable, except in the very rare occurrence of fraud or other similar acts on the part of the arbitrator. Arbitration is often used in labor disputes, businesses, social disputes because of its flexibility and informality. It may save you time, money, sometimes relationships, and to explore arbitration or other ADR processes before heading to court. However, you have to bear in mind that arbitration is not always the cheaper way of settling disputes. Neither is it always the fastest. Neither does it always preserve relationships, as we've been made to believe. There are times where arbitration wouldn't provide all these things that we look out for. But let's look at what are the benefits of arbitration. The benefits of arbitration. It cost to the parties is often moderate compared to litigation in courts. Some organizations that provide arbitration offer sliding fee schedules based on the size of the claim. In some other situation, it's a semi-informal procedure and the rules of evidence are relaxed. There is speed and efficiency in the process. The proceedings are presumed to be confidential and private. The parties may control the process and the procedure. Also, as part of the benefits of arbitration, antagonism remains part of downsides of arbitration is that antagonism may remain between the parties. There is a lack of full range of discovery. There is limited cross-examination of witnesses. Arbitration fees may be substantial, particularly in complex cases. Arbitrators typically make awards without written opinions or explanatory documents. Arbitration is the most formal type of alternative dispute resolution. So if you're looking for something very, very informal, arbitration may not be the best choice. Arbitration sometimes splits the difference when making an award, which may not be a desirable solution. It is either impossible or difficult to appeal an arbitration decision. Punitive damages are usually unlikely to be granted when it comes to arbitration. However, still on the benefits of arbitration, I'm interested you to know that some other few points that we may note on the positive side is that informal investigation is allowed and parties may agree on exchanging documents. The parties have the ability to select their arbitrator or arbitrators. Usually the situation is they appoint two arbitrators, as each party appoints an arbitrator, and both arbitrators now appoint a third arbitrator, making it 3 arbitrators. And this is usually the case to avoid ties and deadlocks when making a decision. If the parties are unable to agree on an arbitrator, the courts or arbitration association may be asked to assist in the process. Parties can select an arbitrator with expertise in a certain subject matter. Unlike in courts, you can't decide which judge sits on your matter. But parties can decide, let's appoint arbitrators that have technical expertise in this area of law. There is no jury and the arbitrator makes the final decision. So this saves time, less bureaucratic, less bottlenecks and all that, and these are the benefits of arbitration. However, let me give you an advice, or let me enlighten you on something that some people do not know. Do you know that an arbitration award can be entered as a court judgment after being confirmed by a court of competent jurisdiction? Yes. To learn more about that, consult your attorney, and that can be a better way of further securing yourself. Because arbitration is not formal, sometimes a party that is not the winning party per se, or the party that is not on the favored side of the decision, may want to frustrate the whole process and frustrate the award that has been given. So what do you do in situations like that to protect yourself? You just take it to court, and the court can enforce that award as if it's a judgment of a court of competent jurisdiction. Like I always tell you, there are lots and lots of things to learn under each of the four topics, like dispute resolution and every other topic we've been talking about. But all we do here is just to enlighten you on what is obtainable, the basics, and get you more curious. However, should you have questions or should you have experiences in these areas and there are questions relating to these areas, that's what my email address is meant for. Send me an email and I'll be glad to take your questions. But when it comes to dispute resolution, generally, I would like you to bear in mind that it's the saying that goes that prevention is better than cure applies. By that, I'm trying to say, do everything in your power to prevent disputes from arising. One of the things I mentioned earlier is to comply by terms of agreements, forestall risks or mitigate against risks, adopt the habit of conducting due diligence exercise, to make sure that all claims are ascertained before venturing into a contract, play by the rules, adhere to all regulatory requirements, do everything in your power to avoid disputes. Because when you do that, you're saving yourself not just time and money, you're saving relationships, you're even impacting the bottom line of your business by giving more hours that you would have spent in dispute resolution to more productive things. So that brings us to the end of disputes resolution. Remember, there are tons of ways of coming into a solution or resolution when you have disputes. Do not be the first to run to court. There are ways you can explore. And if you're afraid about the costs of any of these ADR processes, there's no hard and fast rule about those things. Both parties can agree to, recourse to very, very talented and experienced, skilled people in an area of venture to arbitrate, mediate, conciliate between or amongst them. Yes, that is possible. By that, I'm trying to say there is no rule that says that an arbitrator must be a lawyer or a legal practitioner or a judge. No. Check all the rules. So that means if I'm having a financial issue with a client of mine, we can pre-agree that a chartered financial analyst can arbitrate between us. If I'm having an issue with my doctor, for instance, we have a contract and we have an issue, we can pre-agree that the medical practitioner can arbitrate between us. So it mustn't always be a lawyer. That's the beauty of ADR processes. Anybody that has the capacity, has the technical skills, has the know-how and the experience can mediate, arbitrate, and able to reconcile the parties and help them have a mutually beneficial resolution that can bet about the win-win. I remember in university, our arbitration lecturer will always say, arbitrate, do not litigate. If you check the decades sometimes and the number of years it takes to conclude one case in courts, and sometimes with appeal and all that, it lingers for a very long time. It may not be something you want to venture into. So, think twice before you get into any decision, any agreement, any arrangement. Once you are in, try to play by the rules, try to adhere, try to comply. However, if you've done everything in your power and disputes still arises, as they often do, consult your counsel, consult your attorney, and let them advise you on what best to do. However, if you're a startup and an entrepreneur, you do not have all it takes to make such unbudgeted expenses, or if you are working within budgets and very mindful of expenses, you could pre-agree with anybody entering into contract to, should there be a dispute, let's XYZ, having skill in ABC, arbitrate or mediate or whatever between us. That way, you're saving yourself, like I said earlier, money, time, relationships, and a whole lot more of goodies. Thank you, and see you at the next class. Bye.